When the state of Gujarat has to go to the court, she speaks through the voice of the Advocate General. According to the Constitution, the Advocate General is the highest law officer of the state, a constitutional bridge between the executive and the judiciary. For nearly 2 decades now, this position has been held by one man, a first generation lawyer, Shri Kamal B. Trivedi. From the towering Statue of Unity to Gift City, Sabarmati riverfront to Bullet Train, Gujarat's most iconic projects have had their legal fates argued and successfully defended by him. He is known not only for his command over constitutional law, masterful advocacy that teaches as much as it persuades, but above all, his unshakable integrity. It's a privilege to invite a doyen of the bar, Shri Kamal Trivedi. How are you, sir?
I'm very well. Swayam, I think, thanks for having me and giving a very generous introduction about me. Thank you very much.
You are a first generation lawyer and you've also been the Advocate General of Gujarat for nearly 2 decades. So, firstly, how was it for a first generation lawyer? And secondly, how has the role evolved over this span of years?
Yes, you're right. I'm a first generation lawyer, but law was never in my head. I wanted to become a successful architect or a successful interior decorator. But I somehow fluked to this law, I may say by default rather than by design. It's a history. I may not go deeper into it, but in life, somewhere some motivation factors do play a role. So was the, proposition with me. At the same time, there was nothing for me to fall back. I had clueless. So somebody said, why don't you join law? That's how I joined law. For the first year, I was absolutely not interested. Then I realized that, I need to do and buckle up. And that's how, my journey started. So that's how I think, I'm in the profession.
So perhaps you may not have been architect of homes, but probably in the founding of the immense integrity and the quality of persuasive advocacy, probably you are architect in the Gujarat High Court.
I think I feel flattered. Very well said.
Personally, I have witnessed this. Whenever you enter the courtroom, all the eyeballs are fixated at you. But there is a hidden cost to that, a constant level of scrutiny against you. So how do you deal with the pressure of always being correct?
You're absolutely right. I think, perhaps that phenomenon is common with all public appointments. So there's nothing new or exceptional about the post of Advocate General. But you're right. What I speak, what are my public utterances, how do I, carry on with the matters, how do I argue, how do I dress up, how do I talk with the people, how do I address the gathering, everything being, I may call it scrutinized, criticized, sometimes commended, but it's a part of the whole discipline, and one is to cultivate that. So one is to get, adjusted to it. Because, having learned this, I can't move like a bull in a china shop, what other senior lawyers do, or some of our functionaries of the Advocates Association do. We can't follow. But to have that kind of a discipline in the life, and that to a professional life, perhaps one should try to inculcate if it doesn't have that. So I would like to have that, I'm scrutinized all the while. And that's how I strike the equilibrium.
So I think in a manner that is also perhaps helping you to bring out the best version of yourself, because
I suppose so.
There's always people checking on you.
That's right.
You have seen a generation of judges, lawyers, governments. So what's one thing that should change and one thing that must not?
I think, what should not change and what has not been changed is unwavering faith in the majesty of justice delivery system. Today you go to a common man on the street, last recourse for him is a court. He feels that, if I'm done injustice, there is nobody to, remedy that, court is there. So that faith is, has remained unshaken, and that's perhaps the greatest value which our democratic country possesses. What should be changed and what must be changed? Couple of things, but mainly two. And the present justice delivery system is required to be toned up, more particularly to deal with the menace of delay. I think our proceedings, take inordinately long time. Common people, the people who are languishing in jail, under trial criminals, they have to wait. Supposing for a criminal offense, punishment is of 10 years. So they already spent 10 years. Thereafter, trial will begin. So what is the fate of that? So I think something should be done to take care of this delay. And secondly, this system should be improvised so as to make it, if I may say so, more approachable, more affordable, more accessible, keeping in mind a common man's plight. So if these two things, are changed, perhaps we may have a heavenly feeling so far as our judicial system is concerned.
So it is pertinent to maintain the faith that a common man has in the judiciary. And it is also said that justice delayed is justice denied. Now, on the topic of common man, I have a similar question. So, what do you do when you're assigned a case that you're morally opposed to?
Answer to this question, Swayam, is very subjective, but for me, I will try to draw a line of distinction between what is or something which is morally wrong and something which is statutorily wrong. So far as something which is statutorily wrong, you can have your different shades of interpretation. You can argue the matter. Nothing restrains you from doing that. So far as I am concerned, if something is morally wrong, perhaps I would not like to argue that case. And if I am rather insisted upon to argue, then I would say that these are my instructions and this is my personal perception. I leave it to the court. But this proposition is difficult to propagate for those who have chosen, criminal branch of practice. There you are obliged to defend your client. So I think one is to strike an equilibrium. You try to, go for that line which gives you a mental peace, which feels that at the end of the day, at least I have done my work, keeping in mind, God in mind. So if something morally wrong, perhaps it depends upon individual. So far as I am concerned, I will not do that.
Perhaps to distill your answer, firstly, apart from being an advocate, you're also officer of the court. So maintain the ethical standard. And secondly, because of due process of law, even if you're assigned a case, you should probably adhere to the duty of an advocate, but know where the moral line stands and what the statutory line stands. Now, what does success mean to you now versus when you started your career as a first-generation lawyer?
Somebody has rightly said that early success is to do with something, proving yourself. So naturally, as a young lawyer, at that time, the quest is to win the case at all cost. I think that perception should get diluted over a passage of time. Today, for me, I would treat, my success at par with satisfaction. Satisfaction which I may derive out of various tasks I may undertake. I would like to see that, I do right things which are permissible within the permissible contours of law, rather than winning my case at all cost. I would like to see that I mentor the younger generation to improvise their skill, their ethics. I may get, satisfaction therefrom also. I would like to do pro bono work, which I have been doing all these things. That is perhaps the height of satisfaction. I would also like to build, if I may say so, legacy for trust, faith, transparency, and undoubtedly reputation. Because one thing in this profession is to see that you maintain your reputation. Once reputation is gone, I think perhaps, okay, you may materially become a giant, but people will not look at with that respect eye. I would also like to do that, the judiciary is also helped out, because I am supposed to be maintaining equilibrium between judiciary, the executive and the legislature. And I would like to see that I keep on serving the constitution and public interest. So these are the ways in which I draw my satisfaction, not merely winning the case, which was there when I started at that time. And then I appeal to all youngsters, you should not get that perception at the start. You need to have a killing instinct. And unless you have a killing instinct, perhaps you will not be able to come up.
So when you're in a cave of injustice, only when you have a blemish-free record, only then can you serve true justice.
That's right.
Now, on the topic of talking about success, I would also like to talk about on the part of failure, that is the other side of the coin. Sometimes you give your everything to a case, to a project, to homework, anything. You have given your 110%, but yet you fail. So when you are dealing with high-stake cases and the judgment does not favor you, how do you personally deal with the disappointment or the loss?
I think we all are human beings, so element of disappointment may creep in. I mean, in your case, in my case, when you are young, that creeping in is more lethal. You may get, disappointed in totality. You lose your mood. It happens. But in Gita, it is said that karmenya vadikaraste mahafaleshu kadachina. So you keep on moving. I think ultimately you can't depend upon certainty of fruits. Fruits may come. So all I would like to appeal to the younger generation is that you need to have patience, you need to have passion, and you need to have perseverance. If you can possess these three P's and master them, perhaps disappointment may come and may go. At one point of time, perhaps you will be fully satisfied. And we have in our country the hierarchy of system. If you're lost in a first inning, go to the second appellate forum, then third appellate forum, and a final appellate forum. So if you're right, you will succeed at one point of time. So merely because you are not getting success immediately, don't get exasperated. Ultimately, you have to wait. I think, if I rightly recall, Martin Luther King Jr., who was perhaps one of the most prominent civil rights activists in US, he had become the minister from 55 to 68, if I mistake not. And he was a lawyer also. He had said that, if you can't fly, you run. If you can't run, you walk. If you can't walk, you crawl. But keep on moving without being desirous of any good fruits. You should try to hit the bullseye. And if you don't get, that particular bullseye, don't get disappointed. One day you'll get it. So I believe in that theory.
A lot of young lawyers are briefless. They have the ability, but they lack the visibility. So what are the strategies that you would recommend to them?
Mr. Palkhiwala, he joined the chambers of J.B. Dadachandji. And for 7 years, he did not argue a single brief. He was suffering from two major complications. Number one, he had a stammering voice. He was not in position to speak fluently. I think what we saw Palkhiwala when he came out, like a towering personality, a great speaker, was not Nani Palkhiwala at his prime age. He was practicing in the front of mirror. That where do I commit an error? How do I improvise? Number one. Number two, he was perhaps having no confidence initially. So for 7 years, he says in one of the books that I did not argue a single brief. I was just helping my seniors. So imagine a person who has not got a single brief to argue for 7 years, and after 7 years he comes out like a great towering personality, a great doyen, a great legal luminary. So my advice to the younger generation who are entering the profession, don't be in a quest of getting briefs at an early age. I think perhaps what you should do is you should try to find out by joining the office of a good senior, by getting a good mentoring. Try to see that you attend all the conferences with the senior advocate, with fully prepared, so that the client who is attending the conference may realize that here is a junior, here is Mr. Swayam, who knows perhaps as good as what his senior knows. You should try to see that you inculcate the qualities of your senior. And I don't mind, recommending somebody. You have not one role model. You have as many as half a dozen role models. Don't discuss with anybody. One role model for his style. One role model for his assertion and the argument quality in the court. One role model, the way in which he prepares a brief. I don't say inculcate, I say imitate. That imitation will be of great advantage to you. Perhaps we don't do that. And I don't call the best lawyers are those who know everything. According to me, the best lawyers are those who can read the law, who can adopt the law, and who can analyze and critically think about that. Because it's impossible for one single lawyer to know everything. So perhaps the briefs will come automatically. I may also recommend that youngsters should get register themselves with the District Service Legal Authority, with Gujarat State Legal Service Authority, where at the same time of providing legal aid, You are in position to see that your voice becomes, known in the court. The judges will start, realizing that here is a person who is having, great quality. So then briefs will come slowly but surely, I can assure.
Firstly, on the topic of Nani Palkhiwala, as you stated that he did not argue brief for 7 years, but after a few years, he appeared before the largest bench of the Supreme Court, that is of 13
That's
bench.
right.
And secondly, on the topic of, I greatly resonate with the idea that even if you don't have brief, firstly, you should shadow perhaps a senior, multiple seniors, gain exposure, lessons, and how they conduct their business. And secondly, you can also register with local legal aid clinics. Probably you may not earn a lot, but at least you'll get a brief to argue and showcase your ability. Now, on the topic of accessibility to justice, I realize that we students may not be able to make a monumental impact, but at least what would you expect us young junior advocates or law students to contribute to make justice more accessible?
For law students, I would say that conduct symposium, conduct seminars, conduct podcasts, what you have been doing, to acclimatize the ordinary people about their rights, about their duties, about the provisions of various laws. That is one way of doing it. I think I have come across many of my friends' wards who have been regularly visiting, panchayats, legal clinics, schools, by organizing camps, by inviting some good people to deliver lectures on various aspects which are currently going on in the horizon of the nation. So as a law student, you can do all these things whereby not only you will be able to develop your qualities, but you'll be able to at least know what is happening in the world. And that's how accessibility can be increased. The people will start, knowing about their rights, about their, forums available for ventilating their grievances. And so far as young lawyers are concerned, while practicing, I think they can also attend the legal clinics. They can also once again get themselves registered with the District Legal Services Authority. They can also pursue a career of journalism side by side. I know some gentlemen who are lawyers. At the same time, they are learning lessons of journalism. They are writing columns. And that's how people start coming to know, oh, here is Swayam Shah who is writing a column on tax. Let's go to him. So that's how we'll start getting recognition.
So ultimately, I think legal awareness is the main thing that we must
That's right.
give
So
our time to.
I think try to create that awareness in one form or the other.
I think luckily at GNLU, every year we have a startup conclave where students present their startup ideas and we get funding for it.
Great.
And most of the startups are some or the other way are related to law. So we also have a similar startup where the students go to local panchayats and collect their problems and
That's
solve the
right.
problems.
The kind of environment, kind of facilities you people have. When we were studying, it was, a morning college, 3 periods a day. And after that, people were finding absolutely no time to do anything. They were totally roaming, with no work, no ideas. We didn't have, this kind of moot court competitions. We were not having this technology and tools what you have been using. Nevertheless, we tried to come up. So you have got lots of more opportunities as compared to us.
It's true, we are lucky like that. But at the same time, law is an ever-evolving field and you require vast knowledge. Now, as we as young law students, when we are interning, when we are reading a case law, to understand the current position of law, you need to understand the last 20 years of law. Additionally, tomorrow the Supreme Court may overturn that. So how should we keep up with the ever-evolving nature of law and have a deep-rooted understanding of what the law is?
See, the other day I came across, one of the interviews of Justice Gautam Patel, the former judge of Bombay High Court. I think he is known for his, very frank and candid judgments. And one thing which I liked the most about, his referring to the young lawyers was that the fundamental thing which a young lawyer should do is he should be a lunatic reader. And I connect this with what, one of the great novelists called Walter Scott. He was a novelist from Scotland as well as a lawyer. He said that a lawyer, without the knowledge of history, geography, say poetry, the literature, the ancient literature as well as the modern literature, he is just like a mechanic or a mason. But if he acquires some knowledge of these subjects, history, geography, literature, poetry, he can qualify himself to be called as a successful architect, what you started your comment at the outset. So perhaps I say don't try to do everything. You concentrate on your fundamentals first, namely constitution, civil procedure code, contract, civil law, criminal law, and legal interpretation. Having acquired this, then there is a journey. It is a long journey. And for that purpose, one should be prepared.
Now, on the topic of journey, we have courts, but there's an additional alternative dispute mechanism enforced in the country, that is of arbitration, mediation. Now, in a recent MCIA seminar, you talked about creating an arbitral village, an arbitral township, and you utilized the example of Gift City. So, can you please give me a glimpse of this village?
See, I have a mixed views on arbitration. When we started with this, say, enactment of the 1996 Act, perhaps the hopes were great. Recently, I came across, one of the studies made by a very leading reputed firm, lawyers firm, and they interviewed people like you, the stakeholders, the arbitrators, and they came to the conclusion that more than 60% people are not happy with the arbitration now. They are either dissatisfied or they are ambivalent. So that concept of arbitration with which it started has lost its efficacy. For that purpose, we need to do something new. Of course, we have now a recent bill of 2024, which has come out with number of amendments emphasizing on institutional arbitration. So what I was referring to in that one of the seminars was that why can't we have a village where you go on a pleasure trip. Along with the pleasure trip, you also conduct arbitration. And you have got all the facilities. You have got a facility of lodging, boarding, all your machine tools and technology tools, and the fleet of arbitrators. That fleet consists of doctors, engineers, cost accountants, chartered engineers, apart from lawyers and the honorable judges. And you have one cohesive atmosphere at the same time where you can work like our cricket players. They remain in a bubble. They come, in Ahmedabad, for example, they've got one day. What will they do? They will practice in the morning. In the later part of the day, they enjoy their life. Because that atmosphere is being sought to be given to them. So if that atmosphere is available to people who are practicing in the field, and the parties who are the litigants in the arbitration proceedings, they may get motivated. Yes, we have this kind of a village, and specify the limit of the village statutorily in the Act. This is a village with a jurisdiction like akin to the arbitration proceedings, along with Section 17 proceedings available, along with Section 34 proceedings available, along with Section 37 appeal proceedings available in one village. So you need not to run from pillar to post. And there is a final appeal to the Supreme Court. And only those people will come who are exclusively interested in arbitration. It's a very, very innovative, at the same time far-fetched idea, but one can think of that implementing if we want to see that our country becomes an international hub for the arbitration.
It's indeed a radical idea, but I believe that, again, justice delayed is justice denied, and if alternative dispute mechanisms fail...
Swayam is failing. If I may say so, it has already failed. Today, Section 34 proceedings, apart from arbitration proceedings, they take an inordinately long time. Then 34 proceedings take years. And thereafter, if I go for execution, I don't know when will my award be executed. We don't have sufficient, parameters under the law whereby we can ensure the availability of benefit of the award. Impossible. So according to me, it has failed. And we have got hardly few good arbitrators. I'm sorry I'm being criticized by the fraternity of learned arbitrators, but they are busy. When you go for arbitration, that's what I am told. I never go in arbitration. But my friends say that they check the diary. They say that I have a date only in the next month, and that too only for 2 hours. And I would like to have an arbitration not in this place, on that place. I think why? Why can't we have some kind of a permanent setup? And gift the government is trying its level best to see that that kind of permanent structure starts. So let's hope for the best.
Now, on relation with the government, the Advocate General does not just have the role of arguing before a court, but there are other roles and responsibilities attached as well. So, if you could briefly elucidate on the same.
I think the role of the Advocate General, though circumscribed, though crystallized by virtue of, that Advocate General is appointed under Article 165 of the Constitution by the Honorable Governor, and there are certain other provisions. So, Constitution of India, then we have the Advocates Act 1961, then we have Bar Council of India Act 1961, we have Civil Procedure Code 1908, we have got Contempt of Courts Act 1971. So these are the basic legislations where, roles of the Advocate General have been prescribed. The role has remained the same by and large. But what has been changed is the pressure and the qualitative work of, coming forth from this particular provisions. See, today, that role is multifaceted and which arises out of various matters. Maybe in the matter of amendment in existing laws to keep pace with the time. You may find, plethora of amendments. All the amendments are to be approved by the Advocate General. Then we see, the fleet of new legislations being passed by the legislature day in and day out. They are to be approved by the Advocate General. Then Honorable Governor seeks advice, Honorable Chief Minister seeks advice. Not only that, the concerned ministers as well as the heads of the department. We have got more than 30 departments. So all 30 heads, also will look forward to, getting approved by, maybe they want to pass on the buck that, we have got the approval from the Advocate General. So we do that. Many a times, not many a times, I mean on regular basis, we need to grant sanction under the Contempt of Courts Act. Supposing if somebody wants to really find fault with another individual who is guilty of professional misconduct, then unless Advocate General gives a consent, the court will not start adjudicating upon the matter. The Advocate General is to also file a suit if there is a breach of any covenant of a public trust. Then it is the Advocate General who is to file a suit under the Civil Procedure Code. So is the case with when public trust covenants are breached, Advocate General is to file a suit. At times we need to address the assembly in case of need. Some important issue is to be adjudicated upon. So over a passage and opinions, everyone would like to have a written opinion. So apart from arguing the matter in the court, we have got this kind of roles which an Advocate General is supposed to be taking care of.
So, ordinarily, when I'm concluding the podcast, we generally ask the guest that what is one advice that you would give to a young junior or a young law student. But to you, I would like to tweak the question, keeping the young students in mind. What is your advice to the future Advocate General of Gujarat?
I perhaps may not like to advise like that. Ultimately, if you see, I had two predecessors. One, Mr. J.M. Thakur, a towering personality. He was Advocate General right from 1960 till 2000. His record is unbroken. Thereafter, we had Mr. Shelat, S.N. Shelat. He was Advocate General from 2002 to 2005. And I took the baton from them. What I did, perhaps a newcomer can think of, following that. What I did was, I, tried to follow them. And I find that majority of the qualities of two personalities were so good. I blindly followed them. That qualities were in terms of integrity, in terms of moral values. Once, I tried to find out from Mr. Thakur, who was instrumental in making me independent. I was with one of the firms, earlier. He said, Kamal, you start practicing independently. And similar question I had, sir, who will give me a brief? Then the advice the assertions which I am making, it is nothing but an advice I had got from him. And he said, ultimately, you have to keep, he illustrated, he gave 2 or 3 illustrations. One, it was, in respect of Great Britain story, a real story. One old lady wanted her son to become an advocate. And next door neighbor of hers was, Lord Macmillan of House of Lords. So she was visiting his house and said, sir, I would like my son to become a lawyer. So Lord Bankwilliam counterposed a question that, Miss, would your son like to work like a horse and live like a hermit? She couldn't, understand what did he mean. Then he went on describing his own saga. He said that when I joined the bar, I thought it would be a bed of roses. And I soon discovered either it's all beds and no roses, or all roses or no beds. So that is one example I would like to see that younger generation gets. And number two, which he told me that, ultimately, what is the ultimate exposure you would like to have, apart from arguing the cases, apart from following your great seniors? He himself was a great senior. And I like three things which he said to me. He said that, Kamal, always look up to the Constitution, not as a legal document, but as a moral plan. Number two, and I've taken this, from Mr. Thakur. He said, number two, try to follow Bhagavad Gita, not as a religious book, but as a moral philosophy, will teach you that what are your rights, what are your duties. It speaks about, inner dilemma between the duty and the righteousness. And the third thing, which perhaps we unconsciously believe, he says that look up to God Almighty. Because Constitution is not the final authority. Gita is not the final authority. There is some higher order, which is divine, which is beyond your law and reason. So I will appeal and urge, so far as younger generation is concerned, I think keep on having those three P's, patience, passion and perseverance. Things will come automatically.
With that, we conclude today's podcast. On behalf of myself, on behalf of Saumil Agarwal, the backbone of GNLU Orbiter, my entire GNLU Orbiter team, we're extremely grateful to you for sparing time for us from your busy schedule, and we are extremely, extremely grateful to have you.
Thank you very much, and I wish you all the best, and convey my best wishes to all the student community of GNLU. I think it is known as one of the finest law schools, and they should come out as good professionals. Of course, many of you would like to do the chamber practice, but appeal the thrill which you have in practicing, whereas you may not find that thrill in a chamber practicing. So please do come to the profession. Thank you very much.